We're still waiting for the outcome from the Seventh Circuit U.S. Court of Appeals in the Second Amendment challenge to consolidated cases, arguing that the state's Protect Illinois Communities Act violates the Second Amendment right to keep and bear arms. But we're looking across the country at how different cases in different jurisdictions could possibly impact the state's case. Joining us now to talk about this is Todd Vandermyde. You can follow him on YouTube. Just search Freedom's Steel, and he does deep dives into a lot of this stuff. Todd, we've talked about in the past, the case out of Hawaii where you had a judge say that a ban on butterfly knives violates the Second Amendment. That's been raised in the Seventh Circuit Court of Appeals for the judges to review. You've got a case in the District Courts of California where a judge there declared that that state's ban on certain types of magazines is unconstitutional. Plaintiffs have asked for the courts to essentially review that in the Seventh Circuit. And yesterday we had another case out of Texas that I think, in checking out what you had to say yesterday on this on your YouTube channel, this really gets to expanding the definition of keep. So talk about this. How does the pistol brace ruling out of an appellate court in Texas possibly impact the case you guys have against the state of Illinois?
Hey, Greg. So one of the things that the FFL suit pushed, a suit that I'm involved in, was that, under the New York standard, what is covered by the 27 words of the Second Amendment then becomes presumptively protected conduct, is what the court said. So the burden then shifts to the state to prove that through text, tradition, history, that the regulation is okay, that this is something the founding fathers would have accepted based on those matrix. And so yesterday, a judge in the district court in the Fifth Circuit in Texas sat there, and in a ruling about the pistol braces. Now, this is a ruling where ATF has attempted, through rules and regulations, to reclassify a large swath of pistols as short-barreled rifles. And the judge went on to talk about a concept that I've talked about, the right to repair, to where individuals have the right to repair and work on their own firearms. And he talked about, analogous to the role that stabilizing braces play for contemporary pistol owners, founding era gunsmithing involved modifying lawfully bearable pistols with the extended grips and rearward stocks to facilitate greater stability, control, and accuracy. And so here you have the judge talking about people being able to modify their own guns. He went on to sit here and say, for example, in order to sustain themselves against a large and well-supplied British military throughout the Revolutionary War, the Americans relied on gunsmiths, individuals with know-how from working on their own arms, and Americans who were willing to learn the art of arms manufacturing. So here you have him saying that the gunsmithing, the ability to modify your own firearm, is covered activity within the Second Amendment. It falls within those 27 words. And if it falls within those 27 words, then per what the Supreme Court said in the New York case, it is presumptively protected conduct. The burden falls to the state. And that's one big part here, since we're the only case in the country that's going after semi-auto bans that's talking about the right to repair. Because if we have the right to repair, it leads to a whole host of other things. Because remember, Illinois law bans the acquisition of parts to fix or maintain your firearm, as well as attachments. Well, here they talk about attachments and modifying your firearm. And braced firearms is a category of pistols that the Illinois law bans. And the judge went on to say that these are commonly owned, and therefore, since they are commonly owned and commonly used, that they cannot be dangerous and unusual. He used the ATF's number, where the ATF was saying between 3 and 7 million of these, even though there were higher estimates. and said that because of that, taking the number in the middle at 5 million, they are in common use, therefore they are protected. So this ruling has a whole host of things to impact. I mean, he just basically eviscerated every argument that the state put up that these are dangerous or unusual. Not wrong matrix. It's and not or. That these guns are not commonly used. I mean, and we're just talking about one category of semi-autos, because here we're talking about pistols. And if you remember in the Heller decision, they didn't separate derringers versus revolvers versus semi-autos. They said handguns, period, the end. And he kind of says the same thing. This is a category of handguns, and handguns are protected.
Todd, one thing I think is important is, you mentioned last night kind of the goal that gun rights supporters have is to make the Second Amendment, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. You want to make that an encyclopedia. And I imagine this ruling touches on a well-regulated militia because the militia has to be in good working order and also expanding keep to be not just possess, but to, again, reflect back on being well regulated, keeping those firearms in proper order. We've only got about 3 minutes here, but with the gun registration that started, you've got the accessories. Talk a bit about that and the questions that there are and how that could possibly be vague, as Thomas Magg is going to argue next week in the Southern District. But also, how these cases out of Hawaii, out of the Southern District of California, out of Texas now, how these are going to impact the state. You've got 3 minutes.
Well, we've filed a 28J letter on a couple of the other cases, and I'm sure we're going to be filing a 28J letter, which simply says, hey, court, take judicial notice of this. Something has happened that you should look at. So we're going to be doing that. With the registration stuff, yeah, you look at the video they put out, you look at the guideline they have sent out to law enforcement and to some dealers, evidently. They don't answer a lot of questions that are in the rules. They don't sit there and talk about what exactly is an attachment. If you look at them, all they do is regurgitate the law. And it's funny that on their webpage, they make assumptions. They say that Ruger 1022 in its basic configuration is not an assault weapon, but if it has a threaded barrel or a pistol grip, it is, which their definition of a barrel shroud contradicts what they're saying right there. So there's not a lot of explanation there. I think you'll see a lot of that in the comments to the rules, and they've opened the registration, but it doesn't mean anything because they don't close the registration until December 31st. And on top of that, we may not have a final rule by the time they want to close registration. So I think there's a lot of vagueness in what they are considering an attachment. Their definitions, what they're putting out doesn't necessarily meet definitions of the law. And so I think this is just another mess. And we'll see what's going to happen with the whole thing. But
and then if you could, in less than a minute here, the possible impacts of these other cases on the Seventh Circuit.
Well, I think here what we just saw in the Mock v. Garland cases, they said in common use. They said these are not dangerous or unusual. They talked about how gunsmithing is. All those things are things we have been arguing. The state has argued the opposite side of it, and we have a federal judge that has basically validated everything that we put in our lawsuit against the state of Illinois, and just eviscerated the state argument. So I think that the Seventh Circuit Court of Appeals knows what they have to do, and if they do, I mean, in this case, Mock v. Garland was originally an Administrative Procedures Act, but he dove into the Second Amendment to show the irreparable harm the companies and the individuals were facing. And the stuff I was reading you came out of, hey, this is why it falls under the Second Amendment. And you're right. Yeah, our job is to make the Second Amendment, those 27 words, take up the space of the Encyclopedia Britannica, so that as much of the activity. Well, as Zella's already said, acquisition. Well, if you have the right to acquire, there's got to be somewhere a right to sell. You have the right to maintain proficiency, the right to train. Yet our the marketing law they passed said that you can't advertise certain things that you want to do. So yeah, our job to comply with the New York standard is to make the Second Amendment read like the Encyclopedia Britannica, that all these activities are covered underneath.
Todd Vandermyde, Freedom's Steel on YouTube for deep dives in a lot of this stuff. Greatly appreciate you taking the time. We'll definitely talk again soon, all right?
Frag out.
It is Springfield's Morning News on 92.7 WMAY. Time for a break from Culver's West on Wabash.
Culver's West on Wabash.